at 3:40 today, but sitting again at 10 o'clock tomorrow morning. And we'll take a short break at 11:30 or thereabouts.
Lord Year's. Lord, I appear for the appellant on this appeal with my learned friend Mr. Mark Delahanty, and my learned friends Mr. Stephen Smith, Queen's Counsel, and Mr. Tim Acu appear for the respondent. My Lord, subject to the court, I propose to start with ground 2, which is the first issue referred to in the issues for this court in the agreed statement of facts and issues. The respondent has sought to found jurisdiction against the appellant under Article 5.3 of the 2007 Lugano Convention on the grounds that England is the place where the harmful event occurred. The effect of the decision of the Court of Justice in the case of Beer establishes that a claimant purporting to ground jurisdiction under Article 5.3 has a choice to sue in the courts of the contracting state where the damage occurred, or where the event giving rise to the damage occurred. And ground 2 concerns the identification of the event giving rise to the damage. As the courts below held, and in respect of which permission to the respondent to cross-appeal was refused by this court, the damage which the bank allegedly sustained was its inability or reduced ability to execute against the assets abroad. Accordingly, that limb of the so-called Beer test is not satisfied. So the respondent seeks to ground jurisdiction on the basis of what we call limb B, on the grounds that the place of the event giving rise to the damage was England. In that regard, the respondent says that the relevant event was the hatching of the conspiracy which took place in England. We say the place of the event giving rise to the damage wasn't England, because the event which gave rise to the damage was the alleged wrongful dealing with assets abroad, and not the agreement pursuant to which the alleged wrongful dealings were carried out.
Well, one consequence of your submission is that both limbs A and B point to the same place.
That can happen, my Lord. My Lord, we submit that our conclusion is the correct one, and that results from a principled and correct application of the case law of the Court of Justice. My Lords, our argument has 5 strands to it, and I will now enumerate those. First, the jurisprudence of the Court of Justice is that in seeking to ascertain the event giving rise to the damage in a case of multiple candidate events, one looks to the event which causes the damage. Secondly, we say it's plain in cases such as this, as the cases which we cite at paragraphs 57 to 59 of our written case, that's Core 7, 102 to 103, illustrate, the making of an agreement is an antecedent event which itself causes no damage unless acted on. Third, the respondent relies heavily on the cartel damage claims case, but on proper analysis, we submit that case provides no assistance to the respondent and is in fact against it. Fourth, we submit the Court of Appeal, with respect, fell into error in 3 ways in its determination that the event giving rise to the damage was the making of the antecedent agreement in England. 1, it sought to answer the question, what was the event giving rise to the damage, by identifying the legal foundation for the claim under English law. 2, it carried across to this case an expression sets the tort in motion used by Mr. Justice Ricks in the Domicrus case, which we'll come to, and elevated it to the test to be applied. 3, it invoked the justification and rationale for the special jurisdiction provision in Article 5.3 in deciding what the event giving rise to the damage was, rather than simply applying the limb B of the Beer test.
Say that one again.
So it invoked the justification and rationale for the special jurisdiction provision, specifically 5.3.
Yes, quite.
In how one applied limb B of the Beer test, as opposed to just recognizing it, that it was justification for the special jurisdiction provision itself.
Yes, you're drawing the distinction between what the rule is and what its justification
Exactly.
is, which this court discussed in AMT.
In your Lordship's judgment, with which the other Lordships agreed. That's right, my Lord. And fifthly and lastly, we say that the consequence of the Court of Appeal's conclusion is that there arise inconsistent jurisdictional rules for the economic torts. So, my Lords, I now turn to the first part, the first strand of our argument, namely that the case law of the Court of Justice establishes that the focus is on identifying the event which best satisfies the description of the wrongdoing which causes the damage. At paragraph 55 of our written case at Core E101, we refer to various cases to which I don't propose to take your Lordships, all of which contain expressions which show that the event giving rise to the damage must be causative of the damage. We consider that proposition with respect to be uncontroversial, and indeed we respectfully note that Lord Hodge himself in the AMT case at paragraph 38, that's volume 1, tab 3, electronic 389, in referring to Article 5.3, makes reference to the event giving rise to harm and the relevant harm which that event directly caused. My Lords, I now turn to the second strand.
Wait a minute, you referred to an electronic page, but it's not, the bundles aren't electronically paginated, are they?
My Lord, it's tab 3, internal.
867.
Yes.
867.
And just above letter E,
right,
your Lordship will see the sentence to which I just made reference.
Yes, the issue which has been raised in this case didn't really arise in AMT.
Certainly.
Because the lawyer's procurement of the claims and the damage occurred in Germany.
That's right, my Lord. So, my Lords, I now turn to the second strand of our argument. The cases which we have referred to in paragraphs 57 and 58 of our written case illustrate that the causative effect of a conspiracy is in the overt acts carried out pursuant to it. So, as Lord Diplock noted in the Lonhro case, it is only acts done in execution of the agreement that are capable of doing that. That's to say, causing damage. And we've also cited an extract from the case of Mr. Justice Oliver, the Midland Bank case, which of course was a case about spousal immunity. But we only cite that, again, to illustrate what we respectfully submit to be the straightforward and common sense position that the conspiracy alone, the conspiratorial agreement alone, causes no damage. Rather, what causes the damage are the overt acts done pursuant to that conspiratorial agreement.
Is there a difficulty about these citations that you're switching between saying that the test is a European one and now relying on domestic analysis?
My Lord, no, I don't rely on these cases for domestic analysis. We could have made this point without referring to these cases. These cases just illustrate what I respectfully submit to be the common sense position, which I've just submitted to my Lords. But we don't seek to cut across the submission which we make elsewhere in our written case.
This is basically a European law matter.
This is basically a European law matter.
Yeah. Well, it's the application of European law principles to an English cause of action, so that the elements of the English cause of action can't be disregarded. They are what you are applying the principles to. It's only the principles themselves which have to apply uniformly across Europe.
Yes, I accept that. The cause of action in a national law case suggests the items which go on the menu from which a choice may be made as to what is the event giving rise to the damage.
The difficulty is that the choice is ultimately made by European law, isn't it? I.e., it could put a narrow or a more expansive interpretation on the concept of cause. This is we're here at a delicate interface between the question of interpretation and application.
Yes, I accept that, but that's why we pose the issue as what is the event which best fits the description.
Yes.
And we say that we refer to these cases simply because the judges, in giving the judgments in those cases, have expressed neatly what is the common sense position. My Lords, I now come to the third strand of the argument and the decision of the Court of Justice in the cartel damage claim case. And your Lordships will see that in Volume 1, tab 6, at E451. Your Lordship's reference, it wasn't a case cited before the Court of Appeal. In that case, a Brussels domiciled claimant brought in a German court claims for damages on behalf of various undertakings affected by an anti-competitive cartel between various defendants. The Commission had established that there had been a single continuous infringement, mainly in Belgium, France, and Germany. If your Lordships will see that at E502, internal 957, the Court gave consideration to identifying the event which gives rise, or which gave rise to the damage, which they describe as the causal event. At paragraph 43 on that page, your Lordships will see that the Court identified the causal event, the event giving rise to the damage, as consisting in the restriction on the buyer's freedom of contract. So the difficulty which presented itself was to identify the place of that restriction, it being, in a sense, an intangible event. And at paragraph 44, the special solution which the Court of Justice devised was that in such a case, the place of that event was the place where the cartel was concluded. The restriction on the buyers was coincident on the conclusion of the cartel. Now, in this case, my Lords, we submit that there are no such practical or conceptual difficulties in identifying the place of the wrongful overt acts. What the Court of Justice did not do in those paragraphs was to identify the causal event as the conclusion of the cartel. Further, my Lords, in reference to paragraph...
Didn't it?
Looks as if they did at paragraph 44.
Yeah, once concluded, the participants in a cartel ensure, through action or forbearance, that could be anywhere in the world, that there's no competition and that prices are distorted. Where the place of a cartel's conclusion is known, it would be consistent with the aims outlined in paragraph 39 for the courts of that place to have jurisdiction. That also bears on a different point you were making, how far you look at the underlying aims of Article 5 when you're interpreting its scope.
Yes. But
Are you submitting that the real explanation of these paragraphs is that it was impossible or very difficult to decide where the various acts happened, and that's the only reason why they were driven back to the place of conclusion of the cartel, and that is a point of distinction because here the overt acts can be located. Is that your case?
The distinction is my case, but I would put the distinguishing feature as the restriction on the buyer's freedom of contract, wherever that was felt.
Well, that just happens to be the fact in this particular case.
Yeah.
Are you saying this is are you suggesting that this is a, so to speak, a tailor-made rule for competition infringements?
I do submit that.
I see. So it's got no relevance really beyond that.
I do submit that. It's a case which is relied on by my learned friends in support of the proposition that the place of the event giving rise to the damage is the agreement.
The phrase, the restriction on the buyer's freedom of contract, is a bit tongue-in-cheek, isn't it? Because by definition, this is an illegal cartel and the restriction is invalid. So too in the present case, Mr. Ablyazov and Mr. Khrapunov are said to have restricted their freedom of contract to comply with the court's order. The truth is that the restriction is invalid, but nonetheless, for the purposes of this legal test, it might be said still to be the relevant point.
Well, Lord, with respect, I disagree. As is made clear from the first page of the case, the agreement in the cartel damages claims is unlawful per se as a consequence of the treaty provision.
Right.
In the case of Mr. Ablyazov and Mr. Khrapunov, one is considering an English private law cause of action, which, if one just looks at an English national analysis for the moment, the agreement itself is a constituent part of the tort, but it is not the only necessary element of the tort. And if one leaves aside any national law considerations and just approaches it as a matter of, we respectfully say, common sense, the agreement itself causes nothing. Things have to be done pursuant to that agreement, and we say the things which had to be done in order for the cause of action to be complete were the wrongful acts of dealing against the assets abroad.
But that was equally true of the cartel, wasn't it? The cartel agreement made no difference at all, save insofar as it was acted on.
Well, save that there was a complete cause of action which arose upon the formation of the cartel. That was
But
a consequence.
the complete cause of action test is not the test in 5.3.
I accept that. I accept that.
I mean, can you help me on this? You say that this is a special rule devised for competition infringements. Can you identify the particular feature of competition infringements that requires a special rule?
My Lord, I would simply, in answer to Your Lordship's question, I simply refer to the terms of the particular treaty provision itself. That's all I can...
What is it that you extract from the treaty provision that requires one to look at competition infringements as a special case? The fact that the cause of action is complete upon the agreement.
The fact that the cause of action is complete upon the conclusion of the agreement.
But if 5.3 is not based on the complete cause of action test, why should that make a difference?
Well, my Lord, I simply refer to this case in order to distinguish it from the case at hand. In the cartel damage case, one was dealing with a set of facts quite different, we respectfully submit, from the facts which are presented before my Lord's...
Well, I understand that, but the reason I'm pressing you on this is that unless there's a good answer to these questions, I'm not sure the distinction is very persuasive.
Well, the distinction is that in that case, the Court of Justice did not identify, forget the complete cause of action, but they did not identify the event giving rise to the damage as the formation of the cartel. What they did was to identify the event giving rise to the damage as a restriction on the buyer's freedom to contract, that being a consequence of the formation of the cartel. Of course, damage is a point I've made, that damage is suffered in distortion of prices. It's conceptually difficult to identify a place for the causal event which gives rise to that. And so the Court of Justice fell back on what was a special rule to identify the place of the event giving rise to the damage as the place where the cartel was formed.
This court has held in AMT that in cartel damages there was a special rule as to the place where the damage occurred, i.e. the other limb. But is it so clear that, that in the passage that you referred to concerning the place of the causal event, that the court was constrained to make any special rule at all?
Well, my Lord, we would submit yes, because the special rule in relation to the B test is to identify in a case of infringement of the treaty that the event giving rise to the damage was the restriction on freedom of contract. And the Court of Justice did not say that the place of the restriction was wherever the restriction was felt. They made clear that the place of the restrictions, which were diffuse and spread abroad, was the place where the cartel was concluded. To that extent, we submit it's a special rule. My Lords, we say in this case that there are no such practical or conceptual difficulties in identifying the place of the wrongful overt acts. My Lord, further, in reference to paragraph 61.2 of our written case, it is not simply, of course, that the relevant provision, as I hoped I said, is part of a European treaty having an autonomous meaning, but that the provision makes clear, as I said, that it's the illegal, what's illegal is the entry into the cartel itself. My Lords, I now come to the fourth part of our argument, and that is the three ways in which the Court of Appeal erred. My Lords, its first error was to answer the question as to what is the event giving rise to the damage by identifying the legal foundation for the claim. And in our written case, at paragraph 63, we identify passages in the judgment of Lord Justice Sales which make reference to the legal foundation of the defendant's liability. Your Lordships have the judgment, of course, at core tab 10, and this is particularly pages 183 and 184, and then over the page at 185. Well, Lords, Lord Justice Sales's reasoning is that the legal foundation for the appellant's liability is the alleged agreement with Mr. Ablyazov, and that agreement must be the event giving rise to the damage. And so, for example, if your Lordship sees the repeated references in 76. Now, while Lord Justice Sales was correct in paragraph 77, the top of 184, to state that Article 5.3 is to be given an autonomous interpretation independent of applicable national law governing civil liability, he was nevertheless wrong to state that Lim B of Article 5.3 must refer to the relevant legal event giving rise to liability under national law. Lim B does not require the identification of the place of the event giving rise to liability, whether under national law of a particular member state or at all. That is not what the Court of Justice held in Beer. Indeed, it's well established that the European jurisdictional instruments did and do not intend to link the rules on territorial jurisdiction with national provisions concerning the conditions under which non-contractual civil liability is incurred. And that proposition, of course, is clear from the case of Marinari, and I just give your lordships the reference. That's at 115E709, and the internal is page 230, paragraph 18. And the reason for that, as the Court of Justice go on to explain in the paragraph following, is that otherwise it would be incompatible with the objective of the instruments, which is to provide for clear and certain attribution of jurisdiction. Limb B requires the identification of the place of the event giving rise to the damage. It requires identification of the damage-causing event. And as I said a few moments ago, national law is relevant to identify the acts and omissions constituting the tort or delict, which provide, as we would put it, the menu of choices from which the event giving rise to the damage may be chosen. And in this regard, my lords, we refer to a case in volume 5 of the authorities' bundles, tab 15, the case of Hedgedook. And that was a case...
Can you give us a page number?
Certainly, my lord. So the electronic is 3021 for the judgment. That was a case where the claimant Austrian professional photographer sued the defendant German company in Vienna for copyright infringement.
Sorry, can you give me the bundle and flag reference?
Bundle 5, tab 15. Sued the defendant German company for copyright infringement because it had put some of her photographs on its website without her consent. The court ruled that in such a case, the court of a member state had jurisdiction to rule on the damage caused in that member state, assuming the website was accessible in that state. And I will refer the court to paragraphs 23 to 26 of the judgment, electronic 3025, 3026, internal 564,
Paragraph
23, my lord. And the court ruled that the place of the event giving rise to the damage was at the seat of the defendant German company, and thus that did not avail Ms. Hedgedook, and therefore it wasn't relevant to the case before it.
Which paragraph is that?
So, if your lordship see 23, just below F, in the first place it must be stated that the causal event...
Hang on, you seem to be looking at a different case.
Yes, I think one's got to go to the end.
It's got to go to the judgment of the...
I'm so sorry, I'm looking at the judgment.
Yeah.
I'm so sorry, my lord. 3025, yes, electronic.
No, we are without electronic
Sorry, my lord. So,
numbering, and we're also without internal numbering, so you
I'm
have
sorry.
to give us the pages.
So if your lordships go beyond the opinion of the Advocate General, which consists of about 9 pages, immediately after that, your lordships will see the judgment of the Court of Justice.
It's page 564 of that judgment.
It's page
internal.
5,
Yes.
my lord, yes.
What do you say the electronic is? 3025?
3025.
Appears to be an interesting design.
Seems to work on mine.
Yeah. It does work.
No, I get nothing. Right. All right. We'll carry on. We'll go on the hard copy.
So in paragraph 23, the court says that the causal event isn't relevant for the purpose of attributing jurisdiction to the court before which a case such as in the main proceedings has been brought. That was because the place of that causal event was Germany, and therefore it availed not Ms. Hedgeduck, who had started proceedings in Vienna. In paragraph 25,
So they're not saying it's irrelevant in principle.
Yeah.
It just didn't help her.
that's exactly the point.
It's because the activation of the process for the technical display of the photographs on the website is the causal of events, and that took place in Germany.
Exactly. It didn't avail her because she was suing in Austria.
Yeah.
So paragraph 25, the court says, in a case such as in the main proceedings, the acts or omissions liable to constitute such an infringement may be localised only at the place, and so on.
So
And
this is a pure damage occurred case.
it is. It's a Lin A case.
Yes.
But I show your lordships this passage because paragraphs 23 to 26 are dealing with the Lim B part of beer, though it's said not to be directly relevant to that particular case. And we focus on the words the acts or omissions because that illustrates, we submit, that it is those acts and omissions, that's to say the subject of the victim's complaint, which are on the menu of choices for the event giving rise to the damage. Lords,
Well, I mean, the difficulty is they say in a case such as that in the main proceedings, so it's all very fact-specific, and it's certainly not dealing with combinations or conspiracies.
No, certainly that is right, but it's just an illustration, by reference to that phrase, that the Court of Justice approaches the identification of the event giving rise to the damage by considering, in a non-national law sense, what are the acts and omissions of which complaint is made. And then a choice is made of that which best fits the description of the causal event. My lords, we also refer to the case of Cheval. I don't propose to take your lordships to it now. I just give your lordships the reference, which is in bundle 1 of the tab 22, E889. In fact, maybe I should, lordships want to see that. So it's 122, electronic 889, and in particular, electronic 934.
You'll have to give me the paragraph.
So, yes, so it's paragraph, internal page 63, and it's the part of the judgment which is dealing with the 4th and 5th and 7th questions addressed to the court, and the court will see those questions referred to as electronic 931, internal 60, and they were questions concerned with the extent to which reference could be made to national law.
So which paragraphs should we be looking
And the paragraph which I would rely on is paragraph 41, internal 63, electronic 934. The answer to the referring court must accordingly be that the criteria for assessing whether the event in question and the evidence required of the existence and extent of the harm alleged by the victim are governed by national law, provided that the effectiveness of the convention isn't thereby impaired. So, in other words, national law tells one whether the event gives rise to a cause of action under national law and dealing with issues of proof, but no more. The respondent refers to Cheville in support of the proposition that there's no difficulty in the reference to applicable national laws, how they put it. But with respect, that is too imprecise. National law, and specifically national rules on liability, are not relevant in determining which candidate event or which of a number of candidate events is the causal event. So we submit that these cases illustrate how, with respect, the Court of Appeal went wrong right at the start of its analysis in believing that the causal event limb in Article 5.3 must refer, to use the words in paragraph 77 of the Court of Appeal judgment, to the relevant legal event giving rise to liability under national law. We respectfully submit, had the Court of Appeal not fallen into that error, it would and should have asked the question, what is it that best fits the description of the causal event? And as I've said already to my lords, the alleged conspiratorial agreement is a preparatory step. It can't properly be described as the thing which best fits the description of the causal event. Indeed, we ask rhetorically, if the respondent and the Court of Appeal are right, that it is the agreement which is the event giving rise to the damage, then how does one characterize the overt acts of asset dealing without which no damage would have arisen? The effect of the Court of Appeal decision is that, in effect, those wrongful acts are ignored. But further, my lords, we give at paragraph 69 of our written case an example of an unlawful means conspiracy case which consists of unlawful means which, unlike here, are tortious in and of themselves. In such a case, the same damage is suffered irrespective of whether or not the unlawful means are done pursuant to a conspiracy. In both cases, whether there be a conspiracy or not, the same thing causes the damage, the unlawful means. But the application of the Court of Appeal's liability-focused analysis is that depending upon what national law tortious cause of action were pursued for damages, there would be two different causal events giving rise to the same damage. And we respectfully submit that there's no rational reason for holding, in purported application of limb B of the Beer test, that there are different causal events depending upon what national law formulation is in play on the same facts. Indeed, to do so is contrary to European law, as importing national law considerations in application of the limb B test, which of course give rise to unpredictability and lack of certainty across the member states.
One can test this situation by asking, for example, if it is an analogy, what the position would have been in cartel damage in that case if some of the individual acts or omissions in giving effect to the illegal combination were themselves per se unlawful in the particular country. Surely European law would then look at the overall position and would decide whether the appropriate course was to continue to treat the combination as the underlying cause, the dominant cause, or not. And I take your point that it's most unlikely that European law would say that there were two effective causes it would make a choice, wouldn't it?
Well, my Lord, with respect, I would disagree that that is an apt analogy. The example that we've given is, if I can put it like this, comparing apples with apples, in the sense that one is concerned with two particular national law ways of pleading a case. The example in relation to cartel damage is a particular case because the Court of Justice may have particular views as to how to deal with what are infringements of a Europe-wide treaty. So, with respect, therefore, we don't see an analogy in that way. My Lord, we think our example, with respect, is in point because one can easily imagine that occurring. It's not a wild example. And in such a case, it would be most unlikely, we respectfully submit, that the court would give different answers to the question. As we say, the court is always looking at what is it that best fits the description of the causal event. And if the court is concluding, would conclude, as we think it would, in a case where there is no conspiracy, that it's the tortious acts which have caused the damage, we respectfully say that applying the same analysis under Limby of Beer, the same conclusion would be arrived at in a case even if there was a conspiracy. Lords, we say...
Would that in a conspiracy case of this kind lead to the location of the place of the causative event in a place where the person alleged to be liable didn't commit any of them, but was merely party to the agreement in another place? I think you say it would.
Yes.
So you'd end up litigating against the defendant in a place where he hadn't done anything.
Well, let me answer your Lordship's question this way. It depends if the defendant who's being sued is the only defendant being sued, because if the acts relied on as giving the event giving rise to the damage are not his acts, and there are no other defendants being sued, then the case which I was shortly going to show you, Lordships, Meltzer, suggests that that wouldn't be an applicable event because he hadn't committed the act. It might be different.
So do you say you then fall back on Article 2, there being
Yes.
no Article 5.3 route at all, or you look to see where he did commit a relevant event?
Where he did, or the simple solution is sue the defendant under Article 2 in the place of his domicile, which is that's right, my Lord. So, my Lord, I don't propose to take your Lordships to Meltzer, but we rely on it for the proposition that really the point I've just made in answer to my Lord Briggs's question, that you can't rely, well, first of all, you can't rely on national law provisions for attaching liability, because in that case, the English company hadn't committed any acts, and what the claimant sought to do was use a particular German law rule of attribution of liability to found jurisdiction against the English company. A German company had committed the acts in Germany, and under the German rule of attribution of liability, the claimant said the English company was caught, and therefore we can sue the English company in Germany because of that particular rule. Held, no, you can't do that, because the only person being sued is the English company, and the English company didn't commit those acts. You can't rely on national law to attribute liability in order to found jurisdiction. And, my lords, the point is also made in Meltzer, point which my Lord Briggs made, which is that in case of difficulty, you can always sue the defendant in his place of domicile. My lords, in paragraph 55 of its written case, the respondent seeks to distinguish Meltzer on the facts, but we don't rely on that case because of any similarity of facts, rather for the propositions of law which I've just mentioned and which are set out in our written case. My Lords, I now turn to what we say is the Court of Appeal's second error, namely that it carried across to this case an expression sets the tort in motion, which was used by Mr. Justice Ricks in the Domicrest case, which I'll come to, and elevated it to the test to be applied. And at C5 of our written case, we explain why the Court of Appeal was wrong to rely on the expression used by Mr. Justice Ricks, that the event that results in the damage is the event which sets the tort in motion. Lords, Domicrest was a case, like Cheville, concerned with the problem of attributing jurisdiction in respect of a transnational communication, in effect, specifically where that communication had been identified, or that newspaper article in Francois had been identified as the event giving rise to the damage, but there were problems about where it had occurred. So this case, there is no, it isn't the case that there is no dispute about the identification of the event giving rise to the damage. There are, as your lordships know, 2 candidate events before my lords on the parties' cases, but quite different from Cheville and Domicrest. Your lordships will find the Domicrest case in file 1 of the authorities at tab 10, and
E number, please.
E number 585. And if your lordships go to E604 at internal 567.
Paragraph or internal?
Well, there's no paragraph. It's internal 567, my lord, and it's at letter H from the bottom of the page. And his lordship had referred to the European authorities, including Beer, and the decision of Mr. Justice Steyn, which he departed from in Hyundai. And his lordship says at the bottom of 567H, applying that formula, that's the Beer test, it seems to me that the place where the harmful event giving rise to the damage occurs in a case of negligent misstatement is, by analogy with the tort of defamation, which was the Cheville case, where the misstatement originates. It's there that the negligence, even if not every element of the tort, is likely to take place, and so on. And if your lordships look at E605, internal 568, at letter B, his lordship goes on, it may be argued that in the case of instantaneous communications, and perhaps especially in the case of telephone conversations, the misstatement occurs as much where it's heard as where it's spoken. Nevertheless, it remains true, as it seems to me, that it's the representor's negligent speech rather than the hearer's receipt of it which best identifies the harmful event which sets the tort in motion. That's where the phrase comes from. So the first point to note, my lords, is that Mr. Justice Ricks uses the expression sets the tort in motion in the context of determining the place of an already identified event giving rise to the damage. But Lord Justice Sales, at paragraph 82 of the Court of Appeal judgment, which your lordships find in the core bundle at tab 10, page 185.
Sorry, paragraph?
82.
Thank you.
Has lifted, with respect, that expression in order to justify his reliance on what he has called the legal foundation of the claim. We see that in the words, "this is reflected," 7 lines down from the start of that paragraph. But Mr. Justice Ricks was not using the expression sets the tort in motion in that way. Mr. Justice Ricks was not looking to identify the legal foundation of the negligent misstatement claim. In any case, we would respectfully submit there's a particular difficulty with events giving rise to damage which are identified as communications, because there are several possibilities of the place of that communication. It could be the place from where it originates. It could be the place where it is received. It could also be, conceivably, in some place in the course of transmission between A and B, as it were.
I mean, I can see that there are stray phrases in Lord Justice Sale's formulation which have echoes of the location of the elements of the cause of action, so the old English law rule. But actually what Mr. Justice Ricks was saying, and what I think Lord Justice Sales was saying, although they spoke about the harmful event which sets the tort in motion, they were talking about the harmful event which sets the process in motion that results in the damage. That's actually the essence of both judgments, is it not?
Well, Lord, it's the problem is that throughout this section of Lord Justice Sales's judgment from 76 through to 82, there are many references to the legal foundation of the bank's claim. And in the middle, as it were, of those references, there is inserted a reference to Mr. Justice Ricks in Domicrest. And it's difficult, we think, with respect, to see that as anything other than it being used to lend support, this is how we've read it, to lend support to Lord Justice Sales's national law liability-focused analysis.
I mean, but is this a point that helps you? Because if we accept your submission, we would have to reformulate this as being the place where the process causing loss was set in motion. That wouldn't help you, would it?
Well, I'm not asking the court. I'm certain. No, that's not what I'm asking.
No, I noticed
the court to do. I'm not.
If you knock away this analysis, isn't that what you're left with?
I'm so sorry, Lord.
If you knock away the analysis that you attribute to Lord Justice Sales and simply ask yourself where the harmful event, where the act happened that put the damaging occurrence in motion, you lose, don't you?
If one phrases it like that, I lose. But that is not what the Lim B test prescribes. The Lim B test does not use the phrase sets the tort in motion. It doesn't say that you have to look at the event first in time and follow it through in some causal way. The phrase sets the tort in motion is not a phrase which appears in any of the European judgments, any of the judgments of the Court of Justice. And what the courts have repeatedly said is that it's for national courts to apply the Beer test. And in this...
I mean, the difficulty with all these phrases is that they are synonyms, they're alternative ways of trying to express some causative concept. And the causative concept is that one's looking for what is the real or the relevant cause in European law. We have exactly the same problem in insurance law. People constantly try to redefine the cause in terms of proximate cause or effective cause, so on. But ultimately, there's a value judgment, and whichever phrase you use, whether it sets it in motion or whether it's the foundation or whether it's one of the ones I was using, you are making ultimately a value judgment as to what is the relevant cause. It doesn't strike me at the moment that Domicrest, which is 1999, is doing anything different, or do you suggest it is, from Hajuk 2015, where the European Court looked at the point of downloading of the information onto the internet rather than the point where it was received and accessed.
In that regard, I respectfully agree. But the key point we respectfully mention to the court is this, that in Domicrest, there was no dispute as to what was the candidate event. Mr. Justice Ricks was using that expression, taking his cue, one assumes, from Cheville, in working out where was the place of that already selected candidate event. And in this case...
Well, weren't there two possibilities? One was one candidate event was the place where it was uttered. The other was where it was heard or communicated.
My Lord, no, with respect, not the candidate event. The candidate event was the misstatement, and the possibilities were, well, where did that occur? Did it occur at the point of origin?
Yeah.
Or did it occur where it was received? And so Mr. Justice Ricks...
Well, received and acted on.
And what both of these cases are saying, surely, is that you don't look at the damage and ask what is the nearest act constituting part of the tort to that damage. You may have to look a bit further back and see where the decision was made, or where the process causing damage was initiated. You don't necessarily just confine yourself to the very last event before the occurrence of the damage itself.
In answer to your Lordship's question, your Lordship is right. There's no case law which says that that has to be done. I accept that proposition. But those cases of Cheville and Domicrest are looking at whatever act of the defendant is the one which best fits the description of the causal event. That's all. And in here, there is not, like there is in Domicrest, a unitary, non-composite event. Here one has, and this is the difficulty why we're before the court, here one has a composite tort consisting of, and that is why there are, and in our case, unlike in the Domicrest case, there are two stages. One has the antecedent agreement, and then the acts which are done in execution of that agreement. And we say, when one looks at it like that, I gave the example before of what we said in our written case, where one has a claim where the unlawful means are tortious in and of themselves, and another case where there is a conspiracy. When one looks at it, making a value judgment, that one comes, in our respectful submission, to the same answer, which is standing back. What is it that has caused the damage? What has caused the damage are the acts taken against the assets, which have caused them no longer to be available for execution, or which have diminished their value, or whatever. My Lords, the respondent also refers to a case, DFDS Torline, which your Lordships find, I'm not going to take, actually I will take your Lordships to it. It's at bundle 5 of the authorities bundle. At tab 13, E2971, and it's referred to by the respondents in their written case at 59.2.2. That was a case where a Swedish trades union served notice of industrial action, resulting in a vessel having to be withdrawn and a replacement vessel leased. The claimant sought damages in the Danish courts in tort against the Swedish union for having given notice of industrial action. The Court of Justice held that the event giving rise to the damage was the notice of industrial action given and publicised in Sweden, and therefore Sweden was the place of the event giving rise to the damage. And the judgment, the relevant part of the judgment for that effect is at E2983, internal I-1456, paragraph 41. So the event is there identified. So, and if your lordships go to the decision, or forgive me, the opinion of Advocate General Jacobs at internal 1436 E2963.
What was the alternative jurisdiction suggested here, if it wasn't Sweden?
The alternative jurisdiction was the claimant had sued in the Danish courts.
Right. And what had happened in Denmark?
I'm so sorry, my lord.
What had happened?
Nothing. The ship was registered in Denmark.
Oh, I see.
So nothing. It was a Danish registered ship.
That was the only connection with Denmark.
There was no connection with Denmark, and in fact, the crew was a Polish crew. The Swedish Union were upset about terms offered to the Polish crew. That's why they called out. So, my lords, your lordships see at 1436.
This doesn't seem to be a case which raises the same dilemma that we've got.
It doesn't, but it's not relied on by me, it's relied on by the respondent. And at paragraph 71, in the opinion of the Advocate General...
Sorry, could you give me an E number again?
Yes, 2963.
Thank you.
Mr. Jacobs notes at paragraph 71, in the present case, the event giving rise to the damage is clearly the notification of industrial action. By analogy with Seville, that event must be regarded as originating in Sweden, where the notifications were issued and sent. So it's simply another application of Seville, another communications case.
If the relevant event had been the decision to issue the notices, that would have happened in Sweden as well. So, really, as between the immediate cause and the decision, this case doesn't, on the face of it, help much.
Well, I agree, my lords, but the respondent relies on it, and we simply say, well, it doesn't advance matters from Seville, Domiquest, or the like. Lord, the bank makes the point in relation to this case, in its written case at 59.2.2, that the event giving rise to the damage wasn't the subsequent actions or of union members or other unions, but there is no analogy here, because those actions were not the actions of the union being sued. They were the acts of third parties. The union being sued was being sued for having given an unlawful notice of industrial action. So those potential further acts could not have constituted candidate events. They weren't part of the wrongful conduct for which the defendant was being sued. The giving of the notice was unlawful in and of itself. By contrast, my client here is being sued, and Mr. Abliazov, for the agreement and the overt acts causing damage. My lords, I now turn to the third error made by the Court of Appeal, and I hope to take this briefly, namely that in paragraphs 82 and 87, Core 10, 185 and 186, the Court of Appeal invoked the justification and rationale for the special jurisdiction provision in Article 5.3 in deciding what the event giving rise to the damage was, rather than simply applying beer, the limb of the beer test. And again, we respectfully adopt what this court has held, as expressed in the judgment of Lord Hodge in the AMT case, and we've given references in paragraph 83 of our written case at E111. So far as the point which we make in paragraph 84 of the written case is concerned, we again respectfully refer to the judgment of Lord Hodge in AMT, paragraph 35. That's 1.3E388, and for what is said in Meltzer to the same effect, at paragraph 38, 118, E751, and the internal to that
Sorry,
being
this is Meltzer, is it?
Meltzer 38,
Yeah.
E751, internal 1134. And we also note that in the case law cited by the respondent at paragraph 62 of its written case, the Court of Justice does not say anything different. It doesn't say that the objectives in relation to Article 5.3 are to be applied as part of the process of applying the Lim B test in beer. Lastly, my lords,
Just before you leave that, we have to read the warning in the AMT case in the light of what, for example, the Court of Justice did in the cartel case, don't we? Where, having applied the so-called wording of Lim B, although in fact it's a sort of extraction from the literal wording, they cross-checked to see whether the application of the wording accorded with the underlying rationale for the provision. We looked at that in paragraph 39 of the cartel case. And I note that in the AMT case, Lord Hodge says a claimant cannot establish jurisdiction by merely invoking the justification or rationale. That doesn't stop us, does it, asking whether a particular approach to the wording accords or doesn't accord with the underlying rationale?
well, my lords, we respectfully submit that the rationale is the rationale for the special jurisdiction provision. What has then happened in the sequence of case law of the Court of Justice is that Beer has said that the claimant has a choice, and there has not been, there is no case law we respectfully submit, which says that in applying Lim B in a non-special rules type case, that regard is to be had to the rationale or objectives or justification, because it's already there. It's already there in Article 5.3, and Beer is simply an explanation, in a sense, of how 5.3 is to be applied. And as far as the cartel damage claim case is concerned, there's no cross-checking. Rather, a special rule is being devised, and because a special rule is being devised, it's then being checked by reference to the rationale in order to ensure that the special rule doesn't fall out with the rationale for Article 5.3. My lords, the third error we respectfully submit made, that's what I've been dealing with. We also...
I wonder if that is an answer to Lord Briggs's question. Certainly what the court says in paragraph 29 of AMT is that you're looking for the connecting factor in the rule, and the benefits of that connecting factors aren't themselves the connecting factor. But what prevents the court from looking to those benefits to interpret what the connecting factor is?
Well, my lord...
The connecting factor is the limb, obviously, in beer.
Yes.
But what the meaning of the limb in beer is in the particular case surely can be informed, at least by a cross-check, by the justifications of that factor in the first place.
Well, my lords, I've made my submissions on that point. We respectfully... your lordship knows what your lordship has determined in that paragraph of AMT, obviously.
What?
But, my lord, it comes to...
The word merely is of some importance.
Well, I accept that. My lords...
It would be somewhat of an exception to the general approach to interpretation which courts and including European courts adopt perhaps the European courts above all. We don't just say that the interpretation must be whatever the literal interpretation is, irrespective of the underlying aim of the provision. We normally interpret provisions in the light of their underlying aim, and I don't see that an exception is any different.
Well, my Lord, can I put it like this? That provided the cross-checking doesn't become its own test, providing the cross-checking...
You can't bootstraps. You can't say that it'd be very nice if the aim covered this, and therefore it must.
Well, my Lord, I suspect then there isn't much between us, if I can respectfully put it like that.
I mean, at the bottom of page 865, the benefits which justify the ground of jurisdiction are not themselves connecting factors.
Yes, right. Precisely. So
I think there's very little between us.
I think there is, my Lords. Lords, the consequence of the Court of Appeal's conclusion is that we say that there arise inconsistent jurisdictional rules for the economic courts. I simply refer to what we say in section C7 of our written case in relation to that. And, my Lords, in paragraph 89 of our written case, we have referred to two Lim A cases. I don't propose to take your Lordships to those. We cite them really because, as your Lordships know, the identification of the place of the initial damage is often wrapped up with identification of the event giving rise to damage, unsurprisingly because of the causal nexus between the two. And in those cases, the event giving, well, they were damage cases, but there wasn't a suggestion that the place of conspiring or inducing would have been the event giving rise to the damage. And my Lords, let me give your Lordships references, if I may. So in the Dolphin case, it's bundle 5, tab 6, internal 492, E2776, paragraphs 62 to 64. And in the Actial case, it's bundle 5/2, E2641, and it's paragraphs 6, 19 brackets 4, 34, which must be read with 40, at E2647. I will give your Lordships the internals. 2647, actually, there is no internal because your Lordships have, I'm afraid, the handed down, the approved judgment. So only paragraph numbers. Electronic 2647, 2654, 2658, 2659 and 2660. And finally, my Lords, we simply respectfully refer the Court to a summary of reasons given in paragraphs 90.3 to 90.7 of our written case as to why the appeal we respectfully submit be allowed under this ground. Unless your Lordships had any points which your Lordships wished to put to me on that ground, I propose to turn now to the first ground of appeal, the so-called cause of action ground.
It's sensible to take one's 5-minute break.
Yes, well, perhaps we might take the 5-minute
My
break
Lord, yes.
early. Yes.
My Lord, yes, thank you very much. Lord, there are 5 points which we wish to make and will develop. First, we say that the regime for addressing breaches of court orders is an exhaustive one, namely the court's powers to punish as part of its contempt jurisdiction and its procedural powers, including powers of sanction to manage cases litigated before it. Second, we say that the consequence of such regime being exhaustive, that there is no private law cause of action of any type for damages by way of response to disobedience to court orders. That's the rule for which we contend, the preclusionary rule. Thirdly, we say that the Court of Appeal, albeit with respect having correctly held that there is no direct cause of action for damages for breach of a court order, fell into error by not going further and recognising and giving effect to the rule. Fourthly, there are public policy reasons why the court's regime, contempt jurisdiction and managing cases should be regarded as exhaustive, such that all private law actions of any type for damages by way of response to disobedience to court orders are precluded. Those public policy reasons support and warrant this court, with respect, formally recognising the rule. And fifthly, the effect of allowing the bank's cause of action in this case will be to cut across the exhaustive regime. Lords, I'll turn to some of the authorities which show that the regime is, in our submission, exhaustive and so support the existence of the rule. They are referred to in section B2 of our written case, and I shall also pick up some of the points made in the respondent's written case at paragraphs 16 to 26 of their document. Lords, the first of the authorities which I want to show the court is the decision of their Lordship's House in the Barclays case, which your Lordships find in volume 1 at tab 9. That was a case where payments had been made by Barclays out of an account frozen under freezing injunctions in favour of the commissioners. The commissioners claimed that the bank, as a person notified of the freezing orders, owed it a duty of care in tort to take care not to allow the payments to be made. The House of Lords rejected the proposed cause of action, and I just want to show parts of the speeches of Lords Bingham, Hoffman and Roger to the court, although we've set out some of them in our written case. First, at E556, internal 195, at paragraph 17, I would draw the court's attention respectfully to the way in which Lord Bingham expresses himself in that paragraph in relation to the Morava jurisdiction. The documentation of the freezing injunctions reflects the fact that the only remedy for breach is the court's enforcement of the order by way of punishment. Then, my lords, over the page at 557, internal 196, paragraph 20, his lordship refers, we respectfully submit with approval, to a view expressed by an academic author that there is no right to sue a contem nor for the contempt alone, and that there's no civil right for damages and no power for the court to award compensation to the other party for the contem nor's actions. And his lordship cites one of the, Hudson and Chapman, which I will come to. My lords, then, if your lordships could turn to E561, internal 200, paragraph 39, in the speech of Lord Hoffman, at the end of that paragraph,
Sorry, paragraph
39, his lordship refers to the fact that the order carries its own remedies and its reach does not extend any further. And that's why his lordship was of the view one couldn't derive a duty from an order of the court. And then, my lords, in the same vein, at page 568, electronic internal 207, at the start of paragraph 62, Lord Roger says punishment for contempt of court is the remedy which the law provides for the addressee's failure to comply with an injunction such as a freezing order. And we submit also that the words of Lord Roger in 62 suggest that that's the remedy, even in a case of a deliberate flouting of the order. And we submit that the words of their lordships, which I've shown the court, are clear, absolute, and unqualified, and they support the proposition that the regime for addressing breaches of court orders, including freezing orders, is self-contained, namely the court's powers to punish for contempt and the court's powers in the course of litigation for it to manage that litigation, including by way of the imposition of sanctions. There is no suggestion in any of the speeches of their lordships in the Barclays case that damages are available as a remedy for contempt for breach of a court order. And we would also respectfully adopt what Lord Justice Sales said in the judgment below at paragraph 27, Roman 6, Core 10E 169, namely that the reasoning of all of their lordships in that case, Barclays, was consistent with Lord Bingham's, and that the underlying premise for all of them was that simple breach of a court order does not constitute a cause of action in private law, and that as Lord Justice Sales read Lord Hoffman's words at paragraph 39, that a court order does not create private law duties, and consequently simple breach of a court order does not in itself constitute a cause of action in private law.
It's a, having been in the case, this is a pretty marginal part of the case, these comments, isn't it? The whole case was put on the basis of duty of care, and just looking at the argument, I don't recall any argument about the issues which have been addressed or are being addressed to us today.
Your Lordship is right. The court wasn't addressed on those specific arguments, and the passages which I've shown the court were part of the reasoning of those judges in deciding that it was not appropriate to impose a duty of care on the bank. But nevertheless, we respectfully submit that those passages are clear and indeed express and reflect what we say is the position. And, my Lord, in that regard, I'd invite your Lordships in the same bundle to go to the judgment of Mr. Justice Buckley in Hudson, E667. That was a case of...
Which tab?
Tab 13, my Lord. That was a case of an order embodying a husband's undertaking to pay a third of his income, and upon such undertaking, the order for maintenance was suspended. The ex-wife issued a summons against the current wife, to whom probate of the late husband's will had been granted, claiming an account of arrears. Mr. Justice Buckley dismissed the summons on the basis that absent there being any underlying agreement to pay, there was no cause of action. And I refer to that part of his judgment at E672, E2F, internal 214, an undertaking given to the court unless the circumstances are such that it has some collateral contractual operation between the parties concerned.
So where are you reading from?
My Lord,
E.
214 internal, letter E,
Thank you.
an undertaking given to the court, unless the circumstances are such that it has some collateral contractual operation between the parties concerned, confers no personal right or remedy upon any other party. The giver of the undertaking assumes thereby an obligation to the court, but to nobody else. And Lords, we say...
In that situation where you have an undertaking, presumably the court, I mean, what are the court's powers if the undertaking is broken? The court can probably has rather extensive powers, doesn't it?
Well, the powers of within the contempt jurisdiction.
The position is exactly the same as I understand it, as if an order had been made.
Yes, because the undertaking was embodied in an order.
Well, if the undertaking was to pay a certain sum, couldn't the court enforce that against the person for whose benefit the undertaking was in reality given?
Well, the court's attempt to enforce, as it were in inverted commas, would be by way of the court's exercise of its contempt jurisdiction. But the issue before your lordships is not an issue of enforcement. The issue is whether there's a cause of action which arises for damages. Yeah. My lords, we say...
If the court ordered the sequestration of the contemnor's assets,
yes,
could it direct payment out of the sequestered assets of the sum, the subject of the undertaking?
There would have to be a writ of sequestration.
Yes.
Sequestration
is a normal remedy for contempt.
Of course it is. And there might in due course be an application made to the receivers for payment. But that is quite distinct from...
On what basis would that application be made if there is no private right arising out of the order or the undertaking?
Well, my lord, as part of the enforcement of the contempt jurisdiction, because... But there would have to be an application, but it's part of enforcement. It is not giving rise to a separate cause of action for damages, and that's the key word, for damages, because the claimant or the applicant in the case which my Lord Sumption gives is not there seeking damages, would be making a claim, if that arose, whatever, on the basis that somehow it had the benefit, but it isn't what's occurring in this case.
Anything which the court does, it does pursuant to its powers, even if it could effectively order payment and back up the order with sequestration.
Yes, but it's
but
part.
There's no direct right, you say, no damages right.
Exactly. It's a bit like what Mr. Justice Coleman did in the case of Z Limited against D1, where his lordship, as part of the contempt jurisdiction, made a conditional order for sequestration. But again, as my Lord Manser said, it's different from what we respectfully submit the court is concerned with here. So we say that those two cases, are authority, not just for the proposition that there is no direct cause of action in damages, but they show, we say, that the judges understand that there is no private law action for any remedy for breach of a court order simpliciter. To similar effect is, and I just give you lordships the reference, is the extract of the judgment of Mr. Lord Justice Romer in Hadkinson, which your lordships find at Bundle 3, tab 17, E 1515, and the passage at E 1518, internal, tab 17, internal 288, which is where the learned Lord Justice identifies the two possible consequences. This is at the bottom of 288, 1518. Such being the nature of this obligation, two consequences will, in general, follow from its breach. Not, there are, in general, consequences, and here are two of them, but the two consequences are identified, and the in general refers to the likelihood or otherwise of those two consequences ensuing. My Lord, next, which I don't propose to take your lordship to this case in view of time, but a case which my learned friends rely on, the case of Parker and Rasalingam, a decision of Mr. Lawrence Collins, QC, with reference to that, file 1, tab 20, and that was a case, unlike the case in Re Hudson.
Can I have an E number?
I'm so sorry, I apologise. That is, yes, E761. And the relevant pages are E772 to 773, internal pages 11 to 12. The point being, the deputy judge in that case ordered an inquiry as to damages because there was an underlying agreement, and it was the underlying agreement which was the only basis for giving a compensatory remedy. Lord Justice Sales, in the judgment of the Court of Appeal, suggests that that case, and he says that at paragraph 41, core 10, page 173, shows that a claimant can rely on a breach of an order if he can show that he has some recognised cause of action and relies on such breach as part of that cause of action. Come to that further. And he makes the same point as regards in Ray Hudson. We respectfully disagree. Those cases show no such thing. And we respectfully submit that the fallacy in what Lord Justice Sales says is that there is no reliance on breach of the order per se, rather the reliance is on breach of the agreement underlying, which happens also to be a breach of the order. So we submit Parker is consistent with our contention that there's no private law damages action for what is just breach of a court order and no more, no underlying agreement or the like. Also consistent with our position, we respectfully submit, are the Court of Appeal cases of Chapman and Honig and Nunes and Agrawal. First, in relation to Chapman, which your lordships find at file 1, tab 7, E508. The majority dismissed an action against a landlord on the basis that all he had done was to exercise a legal right, that's to say serve a notice to quit, which he was entitled to do. But in the course of his judgment, at E525, internal, page 519, Lord Justice Pearson, having referred to...
Wait, 525?
525 electronic, internal 519,
No,
top of the page,
yeah,
519.
Yep, I'm with you, yeah.
Having referred to obiter dicta of Lord Denning in the Butterworth case, where Lord Denning had said that there may be a remedy, there may be a redress in a civil court for damages. That's about 12, 13 lines up of 525 electronic. But at the bottom of the page, 5 lines up from the bottom, Lord Justice Pearson says those passages were clearly obiter dicta because no question of civil liability arose for decision in that case. As obiter dicta, when read together and fairly construed, they contain a warning of the risks incurred by a person who acts in contempt of court and don't, in my view, say or imply that there's necessarily in every case of contempt of court of the kind which we're considering a civil right of action for damages. In many cases, there would be such a right. The act of victimization may be itself a tort or a breach of contract, for instance, trespass, and so on, consistent with the cases which I've showed your lordships already. And then later, at E527, internal 521, Lord Justice Pearson paragraph at the bottom of that page, internal 521, 527 electronic, refers to cases addressing the issue of whether there might be a right of action in damages for a breach of statutory duty, and concludes that it depends on the construction of the enactment. Then an ultimate line on E527, 521 internal. Here, there is no enactment which is directly relevant, and I can only consider, perhaps in a rather metaphorical way, what intention is to be inferred from the nature and exercise of the jurisdiction. So far as I know, no individual ever has been awarded or has even claimed damages or other compensation for contempt of court until the present case. The jurisdiction exists and is exercised alio intuitu for the protection of the administration of justice and not for the protection of individuals. So to speak, the hypothetical enactment should be notionally construed as not conferring on an individual affected by a contempt of court any right of action for damages for the contempt of court as such, although, of course, he may have a right of action for damages on other grounds, but he then goes on to say it's not necessary in that case to determine this, whether this is right as a general proposition. But we respectfully submit that those, and I should say Lord Justice Davies also agrees with Lord Justice Pearson. Let me just give your Lordships the reference to that. So your Lordships go to electronic 532, internal 526. The second paragraph on the bottom of the page, I would respectfully desire to express my agreement with the judgment of Lord Justice Pearson, save in one respect, and then the only difference is a matter which is not matters before the court. So, my Lord...
On 520,
yes,
in the first half of the page, is he not contemplating that there might be a right of action for damages, not just where the act of victimisation was itself a tort or a breach of contract, but because the vindictive motive might render, of itself render unlawful an act which without such motive would have been lawful. And he postulates, then he refers at the end of that paragraph to Attorney General Butterworth. There was a possibility that Greenlees might have had a cause of action of conspiracy if it wasn't investigated. There may well be other cases in which the vindictive motive would render unlawful some act which would otherwise be lawful. Does that not postulate that, I think the vindictive motive in this case is the breach of the contempt of court, namely the victimisation of a witness, isn't it? So
that's right, in that case, yes.
Isn't it postulating that something which is a breach of a court order might itself render unlawful some act which would otherwise be lawful, e.g. give rise to an actual conspiracy?
Well, Lord, we respectfully say not, because lawful in lawful means conspiracy.
He says in the middle, just above that, it might cause some concerted activity which otherwise might have been an innocent combination in defence or furtherance of trade interests to be an actionable conspiracy.
Yes, lawful means conspiracy, not relying on there having been a breach. So, in other words, in the lawful means conspiracy case,
no, this is unlawful means. It might the victimisation might be the, as I see it, he's suggesting the unlawful means which would make it unlawful means conspiracy, actionable as such.
Well, we read this as referring to a lawful means conspiracy, where the focus would be on the intention, and so there's no reliance on any breach of a court order, because in a lawful means conspiracy case, it is the act of conspiring with the predominant intention to injure and damage ensuing that gives right to the cause of action. We don't read it as Lord Justice Pearson suggesting that there might be an action for breach of a court order based on vindictive motive. That would not be consistent, we say, with the way his lordship expresses himself at the bottom of internal 519 and the top of page 520.
But either way, even if it's only even if it is concerned with lawful means conspiracy in that it can be used to show that the predominant intention was to harm, doesn't it depart from your general thesis that you can't rely on a mere breach or a breach of a court order as relevant to the creation of any cause of action at all?
Well, Lord, we don't see Lord Justice Pearson as suggesting that breach of a court order gives rise to any cause of action, and that in the conspiracy case which his lordship refers to, there may be reference to acts which are part and parcel of that lawful means conspiracy, but which in and of themselves don't give rise to an action. But he doesn't find that, or doesn't express the view that breach of a court order, even with a vindictive motive and no more, constitutes or would give rise to a right of action. Now, that case has been understood as being authority for the proposition that there are no damages which can be obtained, no private law action for damages arising out of breach of a court order, contempt. We say that notwithstanding that matter wasn't, the ratio of that case was that an act which was lawful, the notice to quit, could not at the same time also be unlawful. But the way in which Lord Justice Pearson expresses himself, as agreed with by Lord Justice Davies, supports that proposition in any event. Lord, the second case is a decision of the Court of Appeal, Nunes. I just give your Lordship the reference. That's at File 1, Tab 19, E753, and the passage in Lord Justice Stuart Smith's judgment, with whom Lord Justice Clarke agreed, at paragraph 12, E755, internal page 3. That was a case where an expert witness had failed to attend the trial of someone who had suffered serious sexual assaults, and the evidence of the expert was important. Because the expert didn't turn up, the defence made a submission of no case to answer, and the judge acceded to that, so the victim brought an action in damages against the expert for breach of what was said to be a duty to take reasonable steps to provide evidence of the assault and attend the criminal trial. And there was an attempt to get round the witness immunity rule. The judge refused the strikeout of that claim, but the Court of Appeal reversed the judge and allowed the defendant's appeal. And Lord Justice Stuart Smith says contempt of court in that paragraph does not itself give rise to a cause of action, referring to Chapman and Honig, and then referring to the fact that there may be a separate cause of action based on the facts which constitute the contempt, and he gives examples, again, not to this case. Lord, then please to the case of Acro Automation and Rex Chainbelt. I don't propose, again, to take your Lordship through that as a case my learned friends rely on. That is at File 1, Tab 2, Electronic 366. That was a case where the Court of Appeal granted injunctions against two parties, the Rex companies, who had acted unlawfully by their obedience to an instruction from a US corporation, SI, not to supply the plaintiff. That instruction of SI's was unlawful, and this is the key point, for two reasons. It was unlawful because it was made in breach of an order of the court, but also it was in breach of contract with the plaintiff. Lord Denning's analysis was that the Rex companies were guilty of the then understood tort of unlawful interference in the trade of another because they had obeyed the unlawful instruction from SI. And we see that from the passage in the judgment of the Master of the Rolls at internal, page 1682, letters G to H, E372, and the instruction of SI was unlawful because it was also breach of contract. Let me give your lordships other references in Lord Denning's judgment. E371B to C, internal 1681, E371H to E372C, internal 1681 to 1682, and E372G to E373C, internal 1682 to 1683. So that's where our understanding derives from. So ACRO is not a case where an essential part of the cause of action was unlawful only because it was in breach of a court order. But in any event, my lords, we say the case is of little utility for three reasons. First, there was no consideration by the Court of Appeal of what we submit to be the exhaustive nature of the regime for responding to disobedience to court orders. Secondly, the consideration of the unlawful means by Lord Denning was undertaken as part of a tort which is no longer recognised, because in that case the unlawful means did not constitute acts intended to cause loss to the plaintiff by interfering with the freedom of a third party, SI, in a way which was unlawful as against that third party. And we rely, of course, for the identification of the tort of causing loss by unlawful means in the speech of Lord Hoffman in OBG, and I just give your lordship the cross-reference, Bundle 4, tab 36, E2027, paragraphs 49 and 51, and the internal cross-referencing is at internal 32. And lastly, the decision, if understood as suggesting that breach of an order, absent some other underlying right, cause of action, could constitute unlawful means, we then say that that would be inconsistent with the decision of their lordships' house in the Barclays case. So, my lords, in conclusion then on the first point, those are the authorities which involve consideration of remedies for breaches of court orders. They either expressly support the exhaustive regime for which we contend, such as Barclays and Re Hudson, or they're cases which are consistent with it, or they're cases which, properly analysed, these other cases, are of no import. And your lordships will have seen from my learned friend's written case, paragraph 27, which is at core 8.128, that there are other cases upon which they rely. I don't propose to take the court to those cases. It may be that we'll come to them in reply if needs be. But broadly speaking, they fall into one or more of four categories, and they are these. First, they are ancient cases, dating back even to the reign of Edward II and Edward III. Secondly, they are concerned with specific cases of disobedience to a witness summons, and which don't survive, we respectfully say, the decision in Barclays, or in any event, they are sui generis. Thirdly, they contain obiter dicta. And fourthly, specifically regarding the TDK tape distributor case, at Bundle 4, tab 42, E2233, referred to at paragraph 27.6 of the respondent's written case, it's said by my learned friends that it's difficult to view that decision as anything other than one awarding damages for contempt. We don't understand the basis for that submission, and if that submission is pursued, we'll pursue it in reply. So, my lords, we now turn to why it is that the Court of Appeal, having rightly recognised that a party cannot sue for damages directly on a breach of a court order, there's no such cause of action, nevertheless held that a party can sue in conspiracy by unlawful means, where the unlawful means are and are only unlawful because they're breaches of a court order. And we would frame the Court of Appeal's error simply as follows. The Court of Appeal did not ask itself why a party cannot sue for damages directly flowing from breach of a court order. Because it neither examined nor appreciated with respect the rationale for its own negative conclusion, it saw nothing wrong in a party being allowed to rely on breach of a court order as part of an unlawful means conspiracy claim. Had the Court of Appeal done so, it would have found that the rationale would be undermined by allowing a conspiracy claim based on breach of a court order just as much as a direct action for damages for breach of a court order. And the decisions of their Lordship's House in the Total Network case, the Hesperides Hotel case, and that of the Court of Appeal in Marinan show, we respectfully submit, that where there is in play a relevant public policy reason which precludes a private law action for particular wrongdoing, the effect is to preclude not only direct actions, but also actions for conspiracy in relation to the same, or any action. And as to Total Network, which I don't propose to take your Lordships to, which is at File 1, Tab 21, E775, I refer to paragraphs 12 to 17 of our written case. The point is simply this: if their Lordship's House had concluded that the scheme for redress in the VAT Act was the exhaustive regime for remedies for the commissioners, which Lords Hope and Neuberger concluded, then the claim in conspiracy would have been precluded, and that would have disposed of the appeal in Total's favour. It was because the majority did not conclude that there was a preclusionary regime that they went on to consider the issue as to whether crimes could be unlawful means. So whilst it's the case that Total Network recognises that the mere non-actionability of wrongdoing doesn't necessarily bar a claim in conspiracy to do that wrong, it doesn't follow that a person can claim in conspiracy by unlawful means for all non-actionable wrongdoing. Quite the opposite. If the non-actionability is as a consequence of public policy considerations pursuant to a preclusionary rule, or public policy considerations themselves, there can be no conspiracy claim. Lords, we also refer to a decision of the New Zealand Court of Appeal, Wagner and Gill, which your Lordships find in File 4, Tab 50, at E2509. Again, I'll just give you Lordship references, not turn it up. We say that's supportive of what I've just said in relation to the Total Network case, namely that in considering non-actionability, it is important to distinguish between the happenstance of non-actionability, such as arose in the Total case, and non-actionability coming about as a consequence of giving effect to an exhaustive regime.
Could you state for me the rule of public policy that you say exists?
The rule of public policy, my Lord, is this: that there is an exhaustive regime for dealing with breaches of court orders.
So is it your submission that the rule of public policy is that you should not be entitled to, well, the distinction is between a state of affairs where public policy says you should not be entitled to sue because actions have this or that deleterious consequence, and a case where there is simply no cause of action. Now, those are two completely different states of affairs. To say that the remedies for contempt are exhaustive, in a sense, begs the question which category it falls into. What do you say are the features of this that bring it into the public policy that you should not sue, as opposed to simply no right of cause of action?
Well, Lord, we say for this reason: there is an exhaustive regime for dealing with breaches of court orders. The court's contempt jurisdiction and the court's case management powers, if you will, which include the power to impose a sanction. If one allows any cause of action in damages for breaches of a court order, and any cause of action which depends upon establishing breach of a court order, then one cuts across or encroaches upon that rule of public policy which says, in relation to dealing with responses to court orders, it's the contempt jurisdiction or the court's case management powers, not actions for damages for breach of order. And we
normally, when this problem arises, the public policy identifies some problem that will arise if people are allowed to sue.
Yes.
Now, I see that you identify an intellectual problem, namely that it means that there are remedies other than applications for contempt. But what is the practical objection to this? Because that's normally the basis on which public policy will say, you can't do indirectly what we object to your doing directly, because if you do it indirectly, you are achieving exactly the same deleterious result that underlies the prohibition on direct action. So what is the deleterious result here?
They are set out by us in our written case at B4, paragraphs 25, 24 to 35, where we give many and several references, which I was going to come on to shortly, as to the problems and difficulties that would be caused if this cause of action were allowed. So I'm happy to deal with those now.
No, I'm perfectly happy to take a reference to those paragraphs as being your answer. That's where I find
that
it.
is, my Lord, yes, that's the answer.
Understood.
My Lords, in the Wagner case, that was a case where there was an attempt to bring a claim in unlawful means conspiracy, where the unlawful means alleged were breaches by a director of fiduciary duties owed to non-claimant companies. And the New Zealand Court of Appeal held that there were strong policy reasons why breaches of fiduciary duty, in that case, should not be recognised as unlawful means. And the reference I give, my Lords, is File 4, Tab 50, E25 22 to 2523.
Can you give me a paragraph
Yes,
number?
paragraphs 80 to 88, which is to be found internal 170 to 171. So we say here there is, at least in the context of freezing orders, an exhaustive, self-contained and comprehensive regime. Lords, in its written case, the respondents...
So that was, the reference to that was 4/50?
4/50, my Lord. In its written case, at paragraph 37.1, Wagner and Gill is dismissed by the respondent as a case concerned with cutting across legislative intent. But the juridical basis for the exhaustive regime is not the point. What is the point is that the regime is exhaustive. And our point is that the claim here fails because it cuts across or encroaches on, which is the verb used by the New Zealand Court of Appeal at 79 in that case, the exhaustive scheme which I've already referred to. And we say there's no principal difference between this case and that of Wagner and Gill. To similar effect are the cases of Marinan in the Court of Appeal and Hesperides, and we give in paragraphs 20 paragraph 20, we've given extracts from the judgment at first instance of Mr. Justice Salmon and then Lord Justice Sellers. Your Lordships know that was a case of a disbarred barrister who brought a claim against two police officers for damages for having conspired to give false statements, defamatory of him, in a report to the DPP and to the benches of Lincoln's Inn, which led to him being disbarred. And Mr. Justice Salmon held that the witness immunity rule was engaged in that case. Therefore, the police officers were not into any civil suit, and that could not be evaded, got around by pleading the claim in conspiracy, because, of course, the allegation or the claim of false statements was an integral part of that tort. So they, therefore, could not be made part of any private law cause of action. And I refer to what we cite there. Let me give your lordships the references. Marinan is at 116E711. That's Mr. Justice Salmon's judgment. Internal, page 238 in that tab, E715. The Court of Appeal judgment is at tab 17 in volume 1, and it's the passage of Lord Justice Sellers' his judgment at E724, internal 535, where his lordship holds that whatever form the action takes, the public policy rule precludes it. Similarly, my lords, in the House of Lords decision in Hesperides Hotel, a case arising out of the annexation of Northern Cyprus, which is at file 1, tab 12, E627, their lordships held that there was no jurisdiction to try an action where the claim was one in conspiracy to procure trespass to foreign land. That was by reason of the Mozambique rule, which precluded the court from trying an action for determining title to or the right to possession of any foreign land or the recovery of damages for trespass to any such foreign land. Because proof of the claim involved proof of the trespass to foreign land, that was a complete bar to the claim, and the reference is in the speech of Viscount Dillon at E660G, internal page 541. As Lord Fraser, in the same case, put it, at E665, internal 546, the conspiracy claim was simply an attempt to dress up the substantive claim in a different guise, and the attempt fails. We submit that the proposition to draw from those two cases is that a rule which prevents a private law action for damages because it would offend against a public policy or relevant public policies applies so as to be effective whatever form or guise the claim takes, including even if the claim is pleaded in conspiracy, because the mischief to which the rule is directed, namely cutting across or encroaching upon the regime, is the same and would otherwise be given rise to. And in this case...
Does Hesperides not turn on the fact that there was no power in the court to investigate title to foreign land in northern Cyprus, regardless of whether it was a freestanding cause of action or in a conspiracy?
Yes, there was no jurisdiction. There was no jurisdiction of the court.
It was purely a jurisdictional point.
It was a jurisdictional point which arose in consequence of public policy expressed in the Mozambique rule.
But the public policy was that it was positively undesirable for the English courts to rule on title to foreign land. Now, more recently, that's been said to be somewhat controversial, but that nevertheless, the public policy in Mozambique was that it was actually so to speak, an offence against the sovereignty of the country in which the land was located. So one can see in that situation, one is not in the no cause of action territory, one is in the breach of positive rules of public policy area.
Yes, but it's an example, we say, of where public policy, if there is a public policy in play, it has effect. In that case, it was expressed by way of precluding the jurisdiction of the English courts. In Marinan, its effect was to preclude any private law action for damages. So too here, the public policy in play, which I've already described, has the effect of precluding not just the direct action for damages for breach of the court order, but any form of action, including the action upon which the claimant sues here. My Lords.
So, I mean, the difficulty is that the public policy, as you defined it, was that there is an exhaustive regime for dealing with court orders, but that slightly begs the question.
Circular.
Right?
Circular.
Yeah, why? I mean, it's not completely exhaustive because you accept that that there are maybe the same conduct constitutes a separate cause of action, but leave that aside. Why should it be absolutely exhaustive? What is there which creates a real inconvenience? I think you get back to the answers you gave to Lord Sumption about your specific point.
Yes, which I'm going to come to, that's right.
Yes, you deal with public policy later in your
That's right.
before and following. Yes.
That's right, but just in relation to the point Lord Mance made, I don't put it by way of there being an exception if there is some underlying right to the order, such as the consent order, because what happens in that case is the claimant sues on the underlying right. So, my Lord, I was going to say a few words about Surza. I'm going to leave that for reply in view of time. I will just say this to headline it. We don't see that the case at all supports the respondent, but in any event, on proper analysis, we say that it supports our case, but I'll deal with that in reply. Lord, I'm now going to turn to public policy and develop the reasons of public policy why the regime should be regarded as exhaustive, a point my Lord Mance made, and specifically in relation to worldwide freezing injunctions, foreign non-parties, and Babanaft proviso situations. And this is addressed in our written case at B4, page 93 in the bundle, and to B6. The Court of Appeal did not examine this aspect at all, having concluded that there was no action for damages for breach of a court order. And we will explain why their lordships in Barclays expressed themselves as they did, and why Mr. Justice Buckley expressed himself as he did in Re Hudson. And if the Court of Appeal had considered the matter, they would have recognised that it was to prevent the mischief which I've already stated to my lords. And in that regard, there is, we submit, a principled distinction between the court adjudicating disputes between private parties and the court's exercise of the contempt jurisdiction and its control of procedure. And there is an exhaustive regime for the latter, which expressly excludes compensatory remedies, as can be seen from the case of Z Bank against D1 at Bundle 4, tab 46, E2306, and the attempt by Mr. Justice, the order of Mr. Justice Coleman in that case, and the necessity in that case for him to fashion a sanction with remedial effect rather than make a compensatory order. And that's, one sees that right at the end. And the rule for which we contend maintains that principal distinction. We don't dispute, as the respondent submits, that there are private interests at play in enforcing court orders, but there is a public interest, very strong public interest also, and we respectfully refer in that regard to Lord Justice Beatson's judgment in Dar al-Arkan. I just give your lordship the references. File 2, tab 9, E1228, and specifically at E1243, electronic, to electronic 1244, internal, pages 150 to 151, and reference, we also make reference to the judgment of Lord Justice Rigby in Seward and Patterson at 440 2198, electronic to 2199, internal 559 to 560, to the effect that although there is no public informer or public officer charged with bringing breaches of court orders to the attention of the court, once the court is seized of the matter, the court acts on its own jurisdiction and on its own authority. My Lords, then at...
But why is that not equally applicable to the... Why is not that supposed policy, if you're right, equally applicable to the invocation of a crime as unlawful means for the purpose of converting an agreement to do it, into something actionable? I mean, crime, again, has a powerful... Generally speaking, it might be said to be the breach of some obligation owed to the state, and the prosecution of it performs a useful primary public function. That's why, generally speaking, crime doesn't give rise to private law remedies.
In a lot of cases, not most cases, the facts constituting the crime will give rise to a tort.
Well, they may or may not, but suppose they don't.
The answer is this, which we derive from total. If there is a public policy or some other rule in play which precludes the actionability for the crime, such as in the total case whether the VAT Act gave rise to an exhaustive scheme, then that provides the answer. And we say here, in relation to breaches of court orders, there is public policy in play, which I've explained to you, and therefore that precludes the matter. My Lords, then we give in our written case at paragraph 26 an example of an action brought after an order has been set aside. And it's a fundamental principle, of course, that an order of the court must be obeyed unless and until it's set aside. So a breach of an order, when in force, is unlawful, irrespective of the fact that it is set aside later. And if any committal application were made in respect of breach of that order, then no doubt the fact of its having been set aside would be taken account of by the court in deciding whether to impose a penalty, or if to impose a penalty, in what degree. But to allow a claimant to bring a conspiracy claim based only on breach of such an order would be a clear cutting across, in that example, of the court's policing function and contempt jurisdiction, because the claimant has a complete cause of action once damage has been suffered. The setting aside of the order which has been breached does not retrospectively erase the previous unlawfulness. So the claimant has a crystallized action. Lords, at paragraph 27 of our written case, we give an example where the court may grant relief from sanctions. That's another example of what we say is manifest inconsistency in treatment and an encroachment into the regimes I've mentioned. We make a related point in paragraph 28 that within the context of unlawful means conspiracy, there would be no scope for taking into account the seriousness or gravity of the breaches of the court order. And indeed it would be inappropriate or impossible, we venture to suggest, for the court to devise a test or means to determine whether breaches of court orders can constitute unlawful means, but other breaches of an order cannot. And the respondents in their written case at paragraph 41.3 do not, we respectfully submit, grapple with that issue. Because in unlawful means conspiracy cases, the unlawful means, and indeed in this case, the unlawful means are unlawful because simply they are breaches of court orders. Severity does not come into it. Severity is not part of the bank's case. It's simply there have been breaches of orders. And one sees this in how the bank has pleaded its case. It's also in the agreement.
Why should the question whether a breach is sufficiently severe to lead the court to impose a sanction, whether committal or fine, bear on the question whether it is a sufficient basis for a conspiracy-based claim? Why are the two necessarily linked? Why is it incongruous if, in some circumstances, the court might take a lenient view of the breach, but nonetheless it founds a claim for damages? It was still a breach.
If there is no direct cause of action for breach of a court order, and we say the basis for that is is the basis that I've been expounding to your lordships, then that follows through to whatever type of action is sought to be maintained based on breach of the order. And otherwise...
Well, that's an assertion, but why does it necessarily follow? I mean, if one starts from the presumption that you can never have anything which can't be sanctioned by the court or wouldn't be sanctioned by the court, well and good. But I was questioning that assumption. Really.
There may be inconsistencies in treatment, and the court loses control of its response to the order. The court's control of the order is found in the contempt jurisdiction, its case management functions. And otherwise, if the order, the breach of the...
It doesn't lose control. It simply means that there's a consequence, which is a civil law consequence in damages, which the court would give effect to in an ordinary way. But why should the court feel affronted if someone relies on a breach of its order as the final key to a conspiracy claim? The court's not going to say, I mean, if the court says there's no breach, then there's no conspiracy claim, so there's no problem. But I don't quite understand why the court should feel affronted if there's a remedy when it itself would not feel it appropriate to impose rather more draconian remedies of a personal nature or financial nature that it has power to.
Because the only remedy in respect of breaches of court orders is by way of the court's powers to punish for contempt, or the court's case. Lord, I know, but
there is an element of circularity.
I appreciate, but the reason for that is explained because of the court's interest, overriding interest, in the enforcement of its orders, and that's why.
But that's not undermined, is it? I mean, does the court have an interest in the non-award of compensation? Simply because it has an interest in punishment. I mean, the functions of punishment and compensatory damages are completely different.
My Lord, I accept that, but the court has determined in relation to breaches of court orders that there is no, we say on the cases, that there is no compensatory element in the way in which the claimant sues in this case. As Lord Bingham said in the case of a breach of a freezing order, the remedy is in committal. The documentation speaks of no other remedy. Lord Hoffman expressed himself in the same way. I appreciate in the context of whether there was a duty of care, but their lordships expressed themselves in very, very clear ways. And for the reasons which I've suggested, based on the policy reasons I've suggested, if that's right, we respectfully say it is, then that carries through to not allowing any form of private law action for damages based on what is a breach of a court order simpliciter. My lords, we then give the possibility of an unlawful means conspiracy case being tried in a foreign court. So, by way of example, the appellant could, if we lose on this ground of appeal, but if we won on the second ground of appeal, be sued in Switzerland. So the Swiss courts would be seized of and address the issue of whether there were breaches of the English court's order. So what if the Swiss court, I ask rhetorically, holds at trial that there was no breach? On the face of it, that gives rise to an issue of estoppel, which would be a bar to proceedings for contempt, even though the English court might take a different view. So a matter as important as the English court's policing of its own orders, we submit, would be taken out of its hands. If there was no estoppel, or if for some reason the English court decided to ignore the Swiss court judgment, then in the exercise of its contempt jurisdiction, there might arise irreconcilable and inconsistent judgments.
But do not the Lugano and Brussels conventions create numerous examples of cases where matters which might be regarded by the English court as important are dealt with by another court of a member or contracting state? The underlying principle being that we respect the courts of all the contracting or member states, save where overriding considerations of public policy are involved, in which case there is a let-out from having to enforce or recognise the judgment.
In relation to private law actions, certainly, but the example that I give is in relation to a private law action vis-à-vis the court's own exercise of its function in contempt. That is, in our respectful submission, the distinction. My Lords, at 41.4 of our written case, the respondent seems to accept that an issue of estoppel might arise, but simply says, so what? It's a price worth paying. But we say, with respect, that misses the point that we make. We then give, in paragraphs 30 to 31 of our written case, an example of how waiver of a court order would operate, where the conspiracy claimant isn't the applicant for the court order. But in any event, when one stands back and considers the matter, we respectfully submit, the real objection lies in a non-applicant for a worldwide freezing injunction being able to claim for damages for conspiracy to breach that injunction. Take an example of an unrelated creditor of Mr. Ablyazov. It might seek to claim in conspiracy against my client and Mr. Ablyazov and rely, as unlawful means, on the breaches of the orders obtained by the bank in its litigation against Mr. Ablyazov, pleading an intention to injure it as one of the class of Mr. Ablyazov's creditors. Now, in that example, the worldwide freezing order would be generative of causes of action for the benefit of parties who were never in the contemplation of the court when it made the worldwide freezing injunction. And as we say in paragraphs 30 to 31 of our written case, to allow such causes of action to arise takes no account also of the wishes of the applicant for the original order, which also are generally respected in the committal regime. My Lords, at paragraph 32 of our written case, we make a point, we put it seventhly, but none the worse for that, that to allow this cause of action would be to open up a raft of satellite litigation. One example is a claim against a director for conspiring with the company, where the unlawful means alleged the company's breach of the freezing order. Or take a divorce case by a former spouse against the ex-spouse and the ex-spouse's new partner, where the unlawful means are alleged that the ex-spouse failed to disclose assets in breach of a court order, with the result the loss was suffered because they were used up later. And it requires, we respectfully suggest, little imagination to see how actions such as these, generated by the cause of action for which my learned friends contend, would clog up the courts. These are not wild or unforeseeable examples.
Just give them again bit more slowly.
My Lord, an example of a claim against a director for conspiring with the company, where the unlawful means alleged are the company's breach of a freezing order, or a divorce case where unlawful means alleged are that the ex-spouse didn't disclose assets in breach of a court order. So one ex-spouse sues the other ex-spouse and the other ex-spouse's new partner. In other words, these are persons who would not otherwise have a cause of action, but for the existence of the breach of the court order. And they claim in conspiracy to take advantage, I use that phrase loosely, of that. At the moment, as we understand the law with respect, there are no such breaches, there are no such actions arise. And we say no such actions should arise. My Lords, in their judgment at paragraphs 55 to 56, the Court of Appeal gives two examples against our floodgates, but I hesitate to use that now because of its pejorative association. But our floodgates argument. First, Lord Justice Sales, at paragraph 55, says...
Can you give me a page?
My Lord, Core 10, page 177.
Thank you.
No floodgates issue arises, since typically either the court order will directly reflect some underlying private law right of the claimant in relation to that person, e.g. where a final injunction is issued to protect such a right. Now, with respect, the learned Lord Justice is wrong. It doesn't apply here because there is no relevant underlying right. Lord Justice Sales appears to be saying that breach of the court order as an unlawful means adds nothing because there would already be some actionable wrong. But what he says is, we respectfully submit, irrelevant to our case, this case, because the unlawful means alleged are alleged to be unlawful only because they're in breach of a court order. And then his lordship, in the same paragraph, goes on to say that, or in the case of a freezing order, will only protect the claimant to the extent that he can establish his underlying claim in damages against that person which the freezing order was issued to protect. Now, that's correct in its reasoning, but it doesn't address our point, because in a case where the claimant has won, the claimant will be allowed to bring in as defendants to his conspiracy claim non-respondents to the original order, and even persons not affected by it. So it isn't the case, if this cause of action is allowed, that it's duplicative, because as to Lord Justice Sales' first example, more people can be claimants, and as to Lord Justice Sales' second way of distinguishing the floodgates argument, as he called it, more people can be defendants. So it has not a duplicative effect, but we respectfully submit a multiplicative effect. And in its written case at paragraph 41.6, the respondent says the courts haven't become clogged with conspiracy cases as a result of total network. But in that case, there was a specific lacuna because of the a conclusion of the majority of their lordships that the VAT Act regime was not exclusive, and because there was no other way that the commissioners could recover. So there was a lacuna of a particular and rare type. My lords, in our case, there are no facts which give rise to a cause of action absent the essential reliance on the court order. So we respectfully submit the respondent is comparing apples with pears. Lords, I now turn to our written case.
Well, why shouldn't it be regarded as an equivalent lacuna if you can't hold responsible in damages someone who has acted as your client is alleged to have done?
Because, my lord, there is no lacuna. The absence of being able so to do is because of the rule of public policy, the rule based on public policy for which we contend. There was only a lacuna in the total network case because there wasn't the preclusionary rule for which total contended. My lords, I now turn to our written case at section B5. In paragraph 56 of the Court of Appeal judgment at page 177, Lord Justice Sales suggests that in allowing this sort of cause of action, liability would only be imposed on a narrow basis, as the co-conspirator would only become liable if, with knowledge of the obligations on the addressee of the order, he deliberately counselled, procured, or assisted in the violation of those obligations by the addressee. In response to that point, we say that that is based on what we respectfully submit is, I hesitate to use the words misunderstanding, I mean no disrespect, but a misunderstanding of the law regarding the requisite state of mind of a conspirator. In that regard, we rely on the decision of the Court of Appeal in the Belmont Finance case, which I just give your lordships the reference to where it is. It's bundle 2, tab 6, E1161, and In that regard, we rely on the extract of the judgment of Lord Justice Buckley at 1172 to 1173, internal 404 to 405, in which his lordship expresses the opinion that the fact that the conspirators were ignorant of or failed to appreciate the unlawful nature of the transaction in question could not excuse them. My Lords, also in paragraph 56 of the Court of Appeal judgment, Lord Justice 177, Lord Justice Sales suggests that liability would arise only in circumstances broadly equivalent to those which would give rise to liability in contempt proceedings under the accessory liability principle explained in Seward and Patterson. The answer to that is if Belmont is right, and your lordships know that there's a debate on that because of merits, such liability arises in conspiracy, even if the third party did satisfy the conditions for imposing liability, accessory liability, in contempt. So we submit that contrary to the understanding of the Court of Appeal, tortious liability would be imposed in far wider circumstances than simply the co-conspirator would be exposed to in contempt proceedings. In its written case, at paragraph 41.7, the respondent, in apparent answer to our submissions that tortious liability would be far wider than the basis for liability in contempt or exposure to court sanctions, says that a claimant bringing a conspiracy claim must establish intention to injure and the use of unlawful means. It adds, this is hardly liability that will be imposed in wide-ranging circumstances.
So what is the reference to this? It's
My Lord, that is the written case of the respondent, 41.7,
yes.
Core 8.
Yes, I'm with you. No, I'm with you.
We say this, first, as to the need to show intention to injure on the part of all conspirators, that is not going to be unusual or, one suggests, difficult in a case of directors and companies, shareholders and companies, for example. Secondly, of course, unlawful means have to be shown, and this is what this appeal is all about. Lords, I now turn to section B6 of our written case and the effect of such a cause of action as contended for by my learned friends on non-parties outside of the jurisdiction. The respondent's cause of action is one which is apt to pay no regard to the terms of the order made, breach of which is said to constitute unlawful means, nor to the scope of the court's committal jurisdiction. We say there should be no cause of action for damages for breach of an order against a person in relation to whom the order is expressly stated to be of no effect. And that is in the terms of the so-called Babanaft proviso. And your lordships will see that in the core bundle at 16 in the freezing order made by Mr. Justice Tierney in 2009, E294, internal of the order 8. And it's at B, the terms of the order will affect the following persons. And then the persons who are affected are expressly identified. So, for example, 1, you don't need to bother about 2 or 3. 1, respondents or their officers or nominees appointed by them, or any trustee and so on, in each case pursuant to written instruments or agents appointed by power of attorney. And the so looking at that order, and we say expressly provides that Mr. Khrapunov, it's not suggested he is so called, is not affected by it. And we say...
Does it?
Well, it is not
Mr. Khrapunov is alleged to have made the conspiratorial agreement within the jurisdiction.
My Lord, it is not suggested that Mr. Khrapunov fulfills these conditions. And, my Lord, in the agreed statement of facts for this appeal, which your Lordship find at tab 6, paragraph 15, 77, Mr. Khrapunov hadn't been served with the Ablyazov WFO or Ablyazov RS receivership order, nor was he respondent to them. Both orders contain forms of the Babinap Proviso, which provides that persons outside England and Wales wouldn't be affected by the order unless certain conditions were fulfilled. Those conditions were not fulfilled in the case of Mr. Khrapunov. And it is also said in the Court of Appeal judgment, which your lordships find in the same bundle at tab 10, paragraphs 14 at page 165, tab 10, page 165, those conditions were not fulfilled in the case of Mr. Khrapunov. And then at 16, in relation to the receivership order, a similar Babinap proviso in relation to persons outside England and Wales. So that's the position. And
That may mean that they weren't fulfilled in relation to Mr. Khrapunov when he was outside England and Wales. But isn't he alleged to have made the conspiracy within the jurisdiction? The whole point of the case was, and that's why they rely on 5.3, that the conspiracy was made in England.
yes, but my lord,
Not the implementation of it. That I understand. That would I think take place offshore.
my lord, leave aside the jurisdiction ground 5.3 for the moment. The question here is whether the order affects Mr. Khrapunov. The order,
While he's outside England and Wales.
and doesn't fulfil the Babinaf conditions. Therefore, he would not be amenable to the contempt jurisdiction. That's the position. The order set, the effect of the order expressly does not affect Mr. Khrapunov. However, if the cause of action is allowed, then because the breach of order relied on is that of Mr. Ablyazov, then there's a claim in damages against Mr. Khrapunov in respect of breach of an order which it is expressly said doesn't affect him. And that is, we say, wrong in principle. And, my lords, the respondents in their written case seek to suggest now at paragraph 43, which is core 8142, that the appellant does satisfy the proviso's conditions. What they say is that Mr. Khrapunov acted as Mr. Ablyazov's nominee or agent when he dealt with the Ablyazov assets. Now, first of all, that is contrary to the agreed position in the agreed statement of facts and issues. Secondly, there is no relevant finding, let alone allegation in the particulars of claim, that the appellant was Mr. Khrapunov's nominee or agent, which are terms of art within trusts law, the meaning of agent under agency law, because otherwise, if they mean whatever the respondent chooses that the words mean, they become meaningless. And a co-conspirator is not without more the nominee or agent of another co-conspirator. And in any case, no such allegation is pleaded against Mr. Khrapunov in the particulars of claim, nor is there an allegation that he held assets, only that he dealt and gave instructions. The case, further response to what my Lord Lord Briggs said, isn't that Mr. Khrapunov was physically in England, but that Mr. Ablyazov was in England, and that it suggested that Mr. Khrapunov communicated with Mr. Ablyazov here. That's the case. So we don't accept at all that the appellant fulfills the Babinap Proviso's conditions. My Lord, in our written case, in relation to paragraph 48, what we mean to say is that a third party abroad should not be subject to a cause of action which seeks to render him liable in damages when an essential component of the liability is in respect of an order which does not affect him. I don't need, obviously, to remind your lordships of the origin and the working out of the Babonap Proviso, the modified Babonap Proviso, the Derby and Weldon Proviso, and the Baltic Proviso, all carefully worked out by the courts in relation to worldwide freezing injunctions. Lords, in our written case at paragraph 49, we make a similar argument in relation to the Baltic Proviso. Your lordships see an example of the Baltic Proviso at core bundle, tab 16, page 295, internal page 9, last page of the order. Nothing in this order shall, in respect of assets located outside England and Wales, prevent any third party from complying with what it reasonably believes is its obligations, contractual or otherwise, under the laws and obligations of the country or state in which those assets are situated, or under the proper law of any contract between itself and the respondent. Now, my learned friends say, oh, well, Mr. Khrapunov doesn't allege that there's any relevant contract. That's not the point. That is simply an ad hominem response to our argument. Our argument is more general, and that is that if this cause of action is allowed, then it brings into the scope persons who are, assuming the Baltic Proviso is not satisfied, who are otherwise expressly excluded from the operation of the order. Lords, we refer in our written case at paragraphs 50 to 51 to the Dar al-Arkan case. I'll just give your lordships the reference at bundle 2, tab 9, at page 1228, in support of the proposition that there are limitations, of course, on the court's powers to serve committal applications outside the jurisdiction. In that case, the Court of Appeal decided that directors or officers could be so served out because they were in a special position as being directing minds, controllers of the relevant companies. But that was a special position. One cannot serve committal applications out of jurisdictions on persons who are not in that category. My lords, we say that if there is a concern in relation to a person in the position of the appellant who, on the bank's case, has conspired with someone, a respondent to an order, in a severe way, then the response is not to fashion a new cause of action. The response could be effected in other ways. There could be modification of the Shabra jurisdiction without there being so much of a focus, for example, on holding assets which are amenable to execution in due course. It could be that there's a relaxing of that or a revision of that it brings into the jurisdiction, the Shabra jurisdiction, persons who don't have to hold assets but who assist in some way. Or there could be an amending of the Babonap Proviso to make it clear, or the Baltic Proviso. But the proper response is not to allow this cause of action. That would be, if I may be permitted to use the aphorism, a case with respect of a hard case making what we respectfully say to be bad law. Unless I can assist your lordships further, those are our submissions.
Yes, Mr. De Alante. Yes. Thank you very much. Mr. Smith, do you want to begin?
Well, if I have a choice, then I prefer to begin at 5 to 2. 2 o'clock.
We say 5 to 2. 5 to 2.